All right, I am here with David Azizi from the law offices of David Azizi, and today we're going to discuss a very interesting situation that recently came up in one of the periodicals. Is a situation where a family with young children rented a home, and the home had a pool, and unfortunately a child went in or wandered out into the backyard and wandered into the pool, and it was a wrongful death situation. And many wondered, is the homeowner liable for the lack of safety around that pool? So David, explain a little bit more about the situation, what is likely to happen as far as the liability of that of the pool.
Sure. We as lawyers get newsletters that advise us of cases that are around or particular issues that are, I guess, new issues that have come about, which we need to know about. And there's a case that just recently went to the 3rd District, which is called Johnson versus Prasad, Prasad. That's 224 Calab 4th 74. And in that case, what happened was, unfortunately, like you said, a little child was drowned as a result of getting to the pool. And it was a situation where the grandmother had left the door to the back leading to the pool open, and the young kid fell in the pool and unfortunately passed away. And obviously the parents filed the lawsuit against the property owner, and their allegation was that the home property owner, being that he was aware that it's foreseeable kids would come onto the property or it surrounded your kids, he needed to enclose the pool to prevent kids falling in there, or have some kind of a door that would close automatically. And in the legal field, there is something that's called the summary judgment. And what that means is that they're saying to the judge, the defense usually, is that there's no factual issue to go before the jury to decide as to whether there's a case or not. So we, as the defense, want you as the judge to summarily dismiss this case and get rid of it because there's no factual issue. Well, the defense filed something of that nature in this case, and they argued that, well, it's not foreseeable that we would notice this, that a kid would come onto the property and fall. And well, the Court of Appeal took back, the judge in the trial court agreed and said, yes, I'm dismissing the case. The parents of the kid appealed and went on appeal, and the appeal court said, no, it is foreseeable that a kid might come on. And there is foreseeable that a landowner has a duty to prevent such an incident from happening. And so the case now has the opportunity to go before a jury, and the jury can then decide factual, because it's a factual issue, as to whether it is foreseeable that the kid would come up, whether the landowner has a duty to put up a fence or a door that automatically closes so that young kids who don't know how to swim do not get to the back pool. So it'll be interesting to see what happens with the case. A lot of times when these things go on appeal, come back, the parties just settle and never gets to see the day of trial. But it's something that we could perhaps follow up and see if it ever goes to a jury or it gets resolved before getting to that point.
Absolutely, and we will do that follow-up as that plays out. And if you have any questions as it relates to a personal injury case, a wrongful death, car accident, a slip and fall injury, please feel free to contact the law offices of David Azizi. You will see the phone number below in the YouTube information as well as above in the YouTube. And thank you for your time, David.
All right, thank you.